All right, so give me a thumbs up if you can hear me. Awesome. All right, so here we go. We're going to jump right into this, and this is not going to be super long, yet it is going to be pretty informative, hopefully. Who knew that this property disclosure statement was going to be changing as of June 1st? By a show of hands. Before you got my email. Yeah, not too many. Yep, kind of snuck up on us a little bit. So, but that's okay. We like little surprises. So let's have a discussion before we jump into this. What is the importance of the property condition disclosure?
Because the client fills it out, it's supposed to be up to date and it's not put off on us. Like they're supposed to disclose any facts that.
Okay. It's a starting point. Yeah, it's basically give an upfront representation of the condition of the property, right? So so what are some facts about the property disclosure that probably get overlooked more than we realize?
The items that are going to stay with the house, or better yet, the items that aren't going to stay with the house.
Okay. Yeah, the property disclosure doesn't go with that too much. There is the personal property disclosure, which is a little bit different, but the property condition disclosure definitely for the items that are staying in the house. That's a good point. Yep. What else? All right, so show of hands or thumbs up or however you want to react. How many of you realize that by having a property disclosure filled out, any transaction in South Carolina actually provides a layer of protection for you as the agent in any post-closing litigation? Who knew that? Okay, see one of you. Yeah, so that's one big thing that we don't understand is we first of all, it's the law. Let's go ahead and get that out there. So filling out a property condition disclosure is actually a law in South Carolina for any transfer of property. We'll go through the exceptions. So that's the first thing. And that's something that we have to understand is if a seller is refusing to fill one out, they do need to consult an attorney because they're going against what the South Carolina law states. It has nothing to do with us as a brokerage, us as a community in real estate, the association, or anything like that. It is South Carolina law. I'm just, for those of you that do want to see this, I'm going to just jump in and show you where that is. So if you do go to the South Carolina legislature, this is where the law is stated. And if you go down here under residential property condition disclosure statements, there's a couple of fancy things in here, but this section right here, the article applies to the following transfers of residential real estate property consisting of at least one or more about the four dwelling units, sale or exchange, installment land sales contract, or lease with an option to purchase contract. So that's the first thing that we've got to understand is that this is South Carolina law, right? So I know this is very granular, yet it's very important because I don't think we take that into consideration when we have clients that may be pushing back. Secondly, by having a property disclosure statement filled out, it does create a layer of protection. And this isn't a law, this is just set in case studies and case law, I should say, is that if we move forward post-closing, like everything with contracts, it's not a problem until it's a problem, right? So post-closing, some litigation comes up. What do you think one of the first things that the E&O company looks for, the attorneys look for, and everyone involved looks for as it relates to the transaction? It's, was it on the property disclosure or was there a property disclosure? Our E&O company actually will waive the deductible in some cases if we have four things. One of them is obviously I won't go through the four, but one of the four is having a property condition disclosures. So you want to keep that in mind as well. So there's a lot of different reasons outside the law that it's super important. Now, let's jump into the exemption part of it because this is where we really get a little mixed up on this. And I want to go through that. Then we'll go through the changes. So scroll down. There are a handful of areas. Let me go back. Did I miss it? Hold this thought. Sorry. Here we go. All right, so these are the exemptions that we go through, right? So one is that they're a court order. This is if it were a foreclosure is a good example. Let's say a house was foreclosed on. That means the bank is taking possession. The transfer is between the homeowner that foreclosed and the bank. So that transfer doesn't require one. To a mortgagee, to a mortgagor, or his successor of the interest of the property. This is kind of repetitive. It says the same thing, but it talks about when the mortgagor takes over the property by fiduciary in the course of administrative a descendant's estate. If you have a property that is being sold in an estate and the owners of the property have passed away and there's an executor to the estate, then that could be considered an exemption. From one or more co-owners solely to one or more other co-owners. So if you have 4 people that own a property together, 2 of them sell to the other 2, that would be an exemption. Made solely to a spouse or persons in a lineal line of what that word is there, meaning if you're selling it to a relative. Made by virtue of records owner of failure to pay federal taxes. So if they seize the property, you don't need it when it's taken from the homeowner to the government. To or from the federal government, which is the same thing. To the state, if it's for whatever reason taken by the state. Involving the first sale of a dwelling that's never been inhabited. This is the first sale. This is new construction. This is one that confuses people because it says never inhabited. That does not mean if you purchased a home and never lived in it, that doesn't mean you're exempt. Real property that is sold at a public auction. And during that sale, it would not need to be have a property disclosure. To a residential trust. If you were to move your property from you owning it into a trust, you don't need the property disclosure in that transfer. Between parties, when both parties agree in writing not to complete a disclosure statement, we're going to come back to that one. A vacation timeshare plan is defined if it's a vacation timeshare, and then a vacation multiple ownership interest as described is again are going to have to do with vacation interest in the property, not necessarily in the entire property itself. Okay, so I've gone through those quickly. Let's talk about some of the highlights where we get mixed up. Number 1 comes with this estate sale. And here's what happens. So number 3 here is what I pointed out. I'll jump back on there, sorry. Number 3 here says by fiduciary in the course administrative of a descendant's estate, guardianship, conservatorship, or trust. Here's where we get mixed up. The property disclosure is not required if the house is in probate and there's an executor. And then it's being sold. Let's say I'm the executor of the estate and we sell it and the buyer, Sarah Waycaster, there's no property disclosure that needs to be filled out. However, if my house, let's say my mom's house, I inherit, she passes away. When that property goes from my mom to me, I don't need a property disclosure. But if I'm now the owner because of that, and I turn around and sell the property, it does need a property disclosure. That's when we get mixed up a lot as people say, oh, well, they inherited the property, so they're exempt. They're not exempt if they inherited it. The actual transfer and the inheritance was exempt, but if they now own it and are selling it on the open market, they're not exempt from it. Okay. The other one that comes up quite a bit is this between parties when both parties agree in writing not to complete a disclosure statement. That can't happen until the 2 parties come together. So when people put that up, they put that as a reason up front, like, oh, well, we agree in writing not to do it. You don't know that the buyer is going to agree to that, so be careful on it. Okay. All right. So everybody with me so far on exemptions? Give me some questions you have.
Joseph, you just said it. I just want clarification because I am actually in this where we had not gone into a listing agreement, but the seller died and the home is in an estate and has executors. So they do not have to fill out the property disclosure statement.
Correct. Now, here's the thing. Here's the caveat on all of this. If there's any time, and I know people get annoyed sometimes because I'm always saying we have to have them talk to an attorney. At any time where exemption comes up, the client needs to confirm with an attorney. Okay. But yes, in that one, as I read it, Sarah, the one that you just said, that because they're an executor, that would fall under is that they are basically administrating the estate as the executor. So one would not need to be filled out.
Thank you.
What else? All right. So What happens in a situation where you do have a client who says, they've either consulted with an attorney or they've said, hey, I'm not going to fill the property disclosure out. I get questions all the time for the property disclosure exemption form. Who can tell me where to find the property disclosure exemption form?
It'd be under the SC forms.
Okay, under the SC forms.
There isn't one.
There isn't one. Alicia, it's a trick question. Sorry, Sarah. There is not an exemption form. Two reasons I bring that up. One is to be completely annoying as it comes to a technicality, because it's just fun. And number two is because there used to be one that was incorrectly created by our local MLS. And it was put out there that you used to be able to go download it. And it had all of these lists of 15 items that I just went through with little blanks next to it to check off. That form never should have existed. However, if you do have a client that is not going to fill one out, here's where you're going to go get them a form to fill out. You go to chsmls.com/documents. You'll come to this page and it's the Charleston, South Carolina property condition disclosure statement notice form. This form you'll have the seller fill out, which is basically a notice that says, we've informed you that per South Carolina law, a property disclosure statement is required to be filled out. You have spoken to an attorney, or you have decided that you are exempt from it and do not want to fill it out, which is, we can't force someone to fill it out. However, this is what we would fill out, have them sign, and then we would upload this in lieu of the property condition disclosure. This form here, again, go to Charleston, chsmls.com/documents, and it is the middle one down on the bottom. And that is the form that you would use for the property condition disclosure statement. Everybody with me so far? Seeing this exciting stuff? Tell you what, yay forms. All right. So now let's go into the actual property disclosure. The changes are minimal. And here's the thing that I want you to keep in mind. This presentation is being recorded. We'll post it so you can watch it again. There's a very short one that the SC, South Carolina Association of Realtors attorney Austin Smallwood created. It's like 4 minutes. It's a very quick and easy one too. Where I do completely agree with him on this is for your information purposes only. This is not for you to then go give advice to your client. The property condition disclosure, one thing that everyone agrees upon is this is a form that they fill out on their own. And you need to be familiar with some of the changes that came about. So let's jump onto the form. Now, the question will come if you've already got the old form filled out prior to this new one coming out on June 1st, it's grandfathered in. You don't have to have a new form filled out or anything like that. So, but this form will be available starting June 1 in all of the form libraries that you have. All right, so page 1, the first place we're going to find a change is that there is a very clear definition on what no representation means. Okay. This is something that you do want to explain to your client. And by explain, I mean just read it to them. Okay. No representation on this disclosure statement. It means the owner is acknowledging that they do not have current knowledge necessary to answer the question with a yes or a no. Owner still has the duty to disclose information that is known at the time of the disclosure statement. No representation should not be selected if the owner simply wishes to not disclose information or to answer the question. Selecting no representation does not waive liability if the owner is aware or subsequently becomes aware. Okay. So basically what this means, as you tell your seller to fill this out, you simply say, you go through, you answer the question. There either is an issue, there is not an issue, or you truly do not know if there is an issue. No representation does not mean I don't feel like representing what I know about the property. It's simply saying you do not have any knowledge of an issue either for or against that specific system. It also says it does not waive your liability if you're aware of something or subsequently become aware of something. So this as always comes up, you have an inspection done on the property, you've already filled out the property disclosure. If the seller then becomes aware of something based on that, they do need to go back and change anything that, even if they had no representation, It's not just changing it from no to yes, it's also changing no representation to yes or no based on what you have found out. Okay, that's the first change. Questions so far? I know, one of the more exciting ones. Here we go. Let's dive back in. Jump to page 2. And we're going to go to sections 5 and section 7. Basically, what they did is they separated this. On the old form, they had roof systems as well as basically the different parts of the home and the structure of the home as far as when they were built, how old they were, that sort of thing. So this has been separated where you have one specifically for roof systems, where you put the approximate year, and then any known roof leaks, repairs, anything that you would put in here, that's separated between 5 and 7 here. Okay. The next part, this is one that is interesting. You will get this question. In section 4, they added or other pest infestations. So what does that cover? Because it said before, any sort of present or past infestation of wood destroying insects or organisms or dry rot, yada, yada, yada. They actually got with the LLR on this with state licensing law and basically came back and said, actually, if there's been any infestation of any other pests, rats, mice, squirrels, bats, whatever it may be, that is a disclosable item on the property disclosure. Now we'll jump down to number 18. They added in number 18 first rights of refusal. Obviously, these things get added because issues had come up. So one of the issues that had come up is people were selling properties and finding out after they would put an offer on the property or go under contract, or basically it really only comes up if there's an offer, putting an offer on the property is that there were a first right of refusal on the property already. Now, I would argue if that property was in the MLS, it should have been active contingent. So this is more than likely happens in situations where maybe a tenant had first right of refusal or whatever it may be, yet just so we're clear, they specifically put in there first rights of refusal as it relates to transferring the property. And then there was a whole bunch added based on environmental stuff. Basically, everything from section 20 or number 22 down to 28. 22, basically any issues you know of erosion control, or any structures that are needed, bulkheads, rock, seawalls, anything that you have there, if there's an issue specific to that. Again, like anything else, if you have yes, the answer to that, you need to put that on later, describe what that issue is. Any flood hazards that you have. So this specifically would go, it just goes into more detail about the flooding on the property itself. How the property is currently insured, if it's through a public program or private flood insurance. And then some more disclosure of the insurance that's on there. Again, remember, most of this is for your knowledge only. It is not going to be made. This isn't something you're going to walk through it with them. Basically, just going to point out if they have any questions, these are the changes. Any repairs that were made to the property as a result to a flood need to be disclosed. Again, if yes, put it later. If there's been any disaster, federal flood disaster assistance based on the flood. One question that could come up on here, this is just a side note that I just thought of, is this is it says any federal flood disaster assistance. The challenge is I spent all day in CE yesterday on disclosure, so I'm a little sensitive on this. So the question that will come up is, well, what if I got some sort of assistance that wasn't federal assistance and it helped me on that? If there's a question, disclose it. An example would be my mother-in-law. So my mother-in-law just sold her house at Pawleys Island. We had bad flooding during Ian. We did not get any federal assistance. However, my mother-in-law did get a KW CARES grant. So that was something that was disclosed when we sold it. Said, hey, you know, property was repaired and work was done via a grant given by yada, yada, yada. Again, did we need to disclose that? Possibly not. Did it hurt to disclose it? Absolutely not. So just keep that in mind. And then this last one is whether the property has been assessed for a beach nourishment project during your ownership. And assessed meaning it has actually been assessed. You know, if they have questions about future assessments or anything like that, again, you'll want the seller to consult an attorney on that as to whether or not they fill it out. So those are the changes to the property condition disclosure. Not many. The format looks a little different. It actually looks a little more uniform in my opinion, but those are the big changes for it. So there you go. Short and sweet. Questions?
Have they ever considered putting the age in of the hot water heater? Because it always gets asked. I mean, they do HVAC and they don't do hot water heater. It just,
Not a bad, I mean, I don't know, but I'll ask.
okay.
I'll ask. I mean, good question. Yep. Okay. What else? What other questions? See,
Date this starts again?
June 1st.
June
So-
1st. Thank you.
Absolutely. So next week. So nothing big. Honestly, I'm glad so many people showed up. I think more of the issue on the condition disclosure we're getting a lot of right now is the use of it. And I will say it is something I can argue both ways on the property disclosure. I can argue very easily that it's worth the paper that it's written on. Right. I mean, because again, the law specifically states this does not keep a buyer from having the right and privilege to inspect the property. That being said, it does provide a lot of protection for both your client as well as you as an agent to have whatever information you can disclosed up front. So just keep that part in mind. The other one that we get a lot, I didn't cover this before, but from the exemption is the never lived in thing. That's just unless it's new construction, brand new construction, that's not an exemption. An investor that's never lived in the house, not an exemption. A flipper that's never lived in the house couldn't be further from an exemption if you tried. If someone came in and literally gutted the house and is flipping it, they actually know more about the house than probably a traditional seller does. They definitely need to fill one out. Just keep those in mind. All right. Any other questions? Perfect. See, quick one. All right. Well, let's do this. We've got some time left. If you want to stay, we can hang out and do some contract masterminds. Throw any contract questions at me. I'm going to stop the recording on this one so we can have this specifically for the property disclosure.